guest today is Dr. Abhishek Singhvi, who's a third-time sitting MP, an eminent jurist, current chair of the Parliamentary Standing Committee on Home Affairs.
No, Commerce. In my left.
Oh. And he's asking the now Commerce. At the moment, Commerce, but he's been on the standing committees on Home and where before that law. He's also a member of the Congress Party's working committee. It's supreme decision-making body, the top senior counsel in the Supreme Court of India, a former additional Solicitor General of India, and a senior-most national spokesperson for the Congress Party, and the chair of the Congress Advisory Board on Law, Human Rights, and the Right to Information. He's going to speak to us briefly on the same-sex marriage case, which has been heard by, I shouldn't say same-sex marriage case, the equal marriage case, because it's not just the same-sex marriage case, which have been heard by the Indian Supreme Court, and the judgment is awaited after some of the solid break. And after that, after his opening remarks, to questions on his presentation as well as on the issue, we'll structure it accordingly. So over to you, Dr. Singh.
Thank you, Professor. And all of you being here. I believe that you are already all blind, fully cognizant, and educated students in law and public law and various issues. So I'm not at all going to try and state the obvious, though some of this will a little repetition to those of you who've been waiting conflict. So I intend to speak for about 25 minutes and then have to, and I'm happy to answer questions. I have friends, sorry, apologies. This is obviously a topic itself, what I call the nature of the beast itself is something which evokes very extreme reactions, not only in India as expected, but to do so in most cultures, most countries. So while I will start with the legal aspects and speak mostly about the legal aspects, towards the end I'll speak a little bit of the larger aspects as well, because it is undoubtedly a volatile cocktail, both for society and the court which heard it, for the participants, for the stakeholders, a cocktail of differing parts and portions, different tastes, fear of the unknown, the progressives' recognition of a great opportunity of reform, a reformist opportunity, the liberals' desire for maximizing freedom in all its aspects, the judges' dilemma at the limits of judicial creativity, and of course the conservatives' disgust at what he considers a useless, idle revolutionary talk. So this is going to be a obvious cocktail. And into that volatile cocktail, the most powerful apex court in the world, powerful in terms of judicial activism, powerful in terms of judicial review, willingly stepped in. So it is by itself the very idea of the court hearing it is an interesting progression in judicial review. And they will be reconciling this heady cocktail in the near future, maybe in July or August. We expect the judgment. The petitioners whom I represented, a whole host, so I'm calling it same-sex only for easy damn, as said more rightly, it is equal sex or equal opportunity case. The real heart and soul, the dilemma, the difficulty was the fact that we were asking, and the other side was opposing, the reading into the existing statutory framework by pure judicial interpretation, the concept of same-sex marriage. So absent legislation, absent a framework, you, the judges, kindly read into the existing law the possibility of same-sex marriage. And secondly, the law is the sole law we were talking about with the SMA, the Special Marriage Act. And if India was to do it next month or the month thereafter, it would be only the 11th nation to have judicially so done. In the company of countries as completely diverse as Austria, Brazil, Colombia, South Africa, Taiwan, USA with city diversity, and also Costa Rica, Ecuador, Mexico, and Slovenia. And I have the details, but I won't go into those. Many of those, of course, these 11, had judicial interpretation, but followed readily in a number of them, happily and willingly also in a number of them, by legislative intervention, which is never going to happen in India, because the vigor and vociferousness of opposition makes it clear that were there to be a judicial recognition, the opposite is likely, a attempted reversal by legislation, but certainly not a recognition by legislation. So the dilemma, the issue was how much can the judges do, which would not be judicial surgery, but merely ironing out the creases, merely some stitches. And that is the issue this way or that. Now, let me very quickly, and you are primarily a legal audience, if I may use that word. It might sound technical, but first part we do is that give you the 7, 8, or 9 building blocks of the legal part of the argument in this case, which is interesting for lawyers, for law students, and there's some amount of legal creativity involved there. Our first and principal contention was to seek a constitution-compliant interpretation, the operative word is interpretation, saying that not interpreting the SMA to subsume same-sex marriage paradigms would amount to a discriminatory implementation of existing statutory law. Discriminatory in particular being based on ascriptive conditions and characteristics. The word ascriptive, as you know, means characteristics which are involuntary, based not on voluntary acquisition of any particular status. Involuntary characteristics such as race, caste, ethnicity, national origin. In this case, the two particular ascriptive conditions on which we said it would be discriminatory not to read in same-sex paradigms were gender orientation and sex. Because these two are, according to us, the only markers of identity to exclude same-sex persons, same-sex again used in the larger sets. And that, we said finally, is a clear violation of Article 14, which, as you know, is the central thematic article on all forms of discrimination and malfeasance or theory of custody. The second was, of course, related closely, the second basis, and that was Article 15, which follows 14, which is specifically bars gender-based discrimination, which we said also would include sexual orientation-based discrimination. The third basis was invoking the more traditional interpretations of Article 14 as created in 1950. Namely, as you know, Article 14's principle, original intent, if I may say it. We have no original intent doctrine in India, but original intent in the general sense, was that you cannot discriminate, but you can do classification between groups, subject to the very important caveat that the classification must bear a reasonable nexus to the object sought to be achieved. So you have to first see the reasonableness of classification on the left hand and the object sought to be achieved on the right hand. And then you had to have a connecting nexus between the two, which nexus itself had to be also reasonable. So we said a exclusion based only on gender or sexual orientation would not be such a valid classification. A, B, if at all it was, it would have no nexus to a reasonable object sought to be achieved, because the object cannot be really contrary to both 14 and 15. Our fourth basis of seeking this interpretation was that you are creating an unequal hierarchy between those who are recognized in their intimate relationships, affirmed and protected by an institution called marriage, versus those who are considered as outsiders in that hierarchy. And that is, again, the similar That's it, but a little different way of putting it, an unequal hierarchy. The fifth was to invoke our Article 19, which has the first subclause on freedom of speech and expression. We said this is a manifestation of your identity and therefore a component of your thought, your expression, right? Your manifestation through those forms of expression. Our sixth basis was to put it in that largest of all articles, other than 14, that is 21, the right to life. And there we said that it is a part of the right to dignity, the notion of dignity, to which we attached as a central core concept the very institution of marriage, the social institution of marriage. An exclusionary paradigm in that respect violated that right to dignity, and therefore Article 21 was it. Our seventh basis was the right to privacy, which, as you know, in the recent past has been now directly sourced to the Constitution in a very large bench judgment. And in particular, in tracing it to privacy, we said that this right is not merely a label. It is not merely a label limited to persons. It is not merely a label limited to persons in private spaces, but applies equally to to spaces, not to persons alone, and in particular within spaces to public space. And therefore, that manifestation of gender and sexual orientation should be allowed in public spaces to persons. To that we added an eighth basis, which is decisional autonomy. Your sense of wanting to do this, to declare yourself, is a core part of decisional autonomy, which falls under many of these notions of Article 21, dignity, etc. There was an important basis, the last major constitutional basis of doctrine of proportionality, which was invoked, is now a central theme of Article 40 of our Constitution, proportionality. There are a large number of judgments in Indian case law, and it has the same tests, those 5-fold tests or 4-fold tests, as you have in England or elsewhere about proportionality, which we applied. Namely, you must first disclose a legitimate state object before you curtail or invade a particular right of freedom. Second, that must have a rational nexus. That the infringing measure must have a rational nexus with that state object. Thirdly, the necessity must be tailored to least restrictive. These are all proportionality aspects you study anyway. Fourthly, there must be a balance between the state object and the extent and severity of the infringement, and so on and so forth. I won't go into the technical part, but you understand proportionality. Now, this being the 7, 8, or 9 basis of the arguments, we had to face the central dilemma, which privately we admit, but I don't think it's an insuperable dilemma. But the court obviously put that to us, because they also recognize that, just as we privately admitted, that we had this, not the dilemma only, but the, if I may say, the paradox is a better word, or the contradiction inherent in our arguments. What was that? That was obviously the fact that, on the one hand, we swore by the SMA. We did not and could not ask for it to be struck down, because for it to be struck down would be like leaving ourselves naked with no clothes available. Our only platform for relief was the SMA. So we had to mount this challenge, which we called a strange challenge, because there's no challenge to the SMA. In the same breath, while not seeking invalidation, we sought reading up or reading down, as you might like, or reading up is a better word, of the SMA in its existing avatar to include same-sex marriage. So the court considered it a little opportunistic, a little self-serving, that you want to have your cake and eat it too and not show it on your whiskers. So logic is not the uppermost basis of this argument. It is some degree of opportunism and convenience. According to us, this is not an insuperable obstacle. You do reading up and reading down all the time. It is not something anathema. And therefore, if you find merit in our basis, if at the heart of the argument, broadly reading same-sex couples into words like wife and husband, or reading the neutral word persons into words like spouses, etc., does the job, then you should jolly well do it, because it makes it for a constitutional compliant interpretation. That is the just answer, and the way of looking at it as far as reading up and down the slips. Now, the third aspect, a very rather interesting and unexpected till we researched it, we didn't realize this very remarkable and strange connection with England. As you know, and as public lawyers know better than anything else, the Indian Constitution itself is a very comprehensive, advanced document. Years of judicial review on that have made it the most dynamic court or system in the world. I mean, I always say Marbury and Madison can blush. So many other things are far, far behind. Globally, I'm not talking about only India or Europe or Asia. And therefore, rightly, if there is one area where English law is hardly looked at ever in India, even in the early 60s, 70s, and 80s, now, of course, it is much less looked at anyway. But even when we were looking at English law, we would hardly look at English law in the area of public law, because England was considered a most backward country as far as public law is concerned, rightly so. Not only the unabridged constitution, your dynamism in judicial review was obviously limited. And of course, you had no human rights treaty, and you had no, European system and court, and did whatever you pay supreme. But even after that came, European treaties came, your system became more external, less insular. Even then, it is nowhere near judicial review of the kind you are used to. So we have no need to. But here, we turned and looked at England very closely. It became, in fact, a central theme of our arguments. How was that? Because a constitutional matter of public law was being argued contradictorily only on interpretation. These are the interesting facets for lawyers. It was really only an argument of interpretation because we couldn't touch the SMA. There was no invalidation involved. So for interpretation, we turned to Khaidan, your UK Supreme Court or UK House of Lords judgment, 8 years ago, 2004. And one of the judges on the bench called it India's Khaidan moment, which is quite a tribute to the fact that we were looking at public law in England. So let me take a few minutes on Khaidan and how it was applied. It's a pretty opposite example according to me. Although, of course, you could always contextually differentiate. Khaidan was a narrow, nitty-gritty private law dispute led to the interpretation. The interpretation part applied completely to India in our case. But the context was very narrow and small. Our context was a big canvas, same-sex marriage. But I would still say the principle applied very opposite. Khaidan was landlord Khaidan suing a chap called Godin, claiming possession of a flat, where Godin said that the recently deceased tenant James was my living partner in a homosexual arrangement and claimed to be as entitled successor under an act in this country, which in para 2 bracket 2 had the phrase, quote unquote, a person who was living with the original tenant as his wife or husband, unquote. And the second part you must know contextually is that it came after the UK Human Rights Act, which has another para, which says that as far as possible, quote, read and give effect to legislation compatible with convention, right? And that says as far as possible. Now, the Court of Appeal also held that this same-sex relationship would be entitling Mr. James to continued occupation of possession of the property. And they did that by reading it by interpretation to me as if they were husband or wife, even though they were not husband and wife, neither in marriage nor in sex. So that was good enough. But what was remarkable was what the House of Lords did. The House of Lords could very easily have affirmed the result on the narrower, but still a fairly significant interpretation advance. The House of Lords did, I would say, something revolutionary, especially having been a student here in the 70s and 80s. It was unthinkable. And even now, I think it is quite revolutionary. they enumerated on interpretation, which is why it is relevant in India, a threefold test, a remarkable threefold test. The first was of this three-pronged test. They said excessive concentration on a literal or technical approach of the statute should be eschewed. That is a big thing for the English word to say, interpretation. Second, they stress that ambiguity in statutory language is not an essential condition before you start going on purposive interpretation. They said purposive interpretation is the right approach, and it's not necessary to first find an ambiguity and then say we find an ambiguity and now we have to leave it as true literal and then go to purposes. And then instead of go to purposes. Third, remarkably, they said these approaches are necessary and have relevance, quote, even if the statutory language is not capable of varying two possible meanings. Again, very interesting for an English word, or for that matter, very common law word, for that interpretation. And fourthly, and in particular, Lord Nichols went that far, said, conventional compliant mandate empowers courts even to change the meaning of legislation. That's why we cited it in India. And there's a quotation by Lord Nichols, which I'll not read to you. Very interesting. It goes very far. And it says, it is only bounded by what is possible. In a sense, they then added, of course, two conditions, which in a sense is part, what I would call my own analogy, it's not appropriate, but it's interesting. The important, the basic structure theory of India into interpretation. They said that we are doing this purposive interpretation because we must look at, quote unquote, two phrases they used, a fundamental feature of the legislation, quote unquote, and second, the creation of the legislation. This is exactly what we do when we do basic structure in India, but in a different context of invalidation. They apply this in the interpretation. Finally, lastly, they said that these are all plus progression. The boundary is also there. There are two boundaries. One is that the court should not do all that we have said they should do if they are institutionally not equipped. And institutional equipment means either that the courts will have to actually draft a detailed statutory framework. Then you should stop. You should not do that. Which is pretty much similar to what the Indian courts also say. Second, so there's a huge policy choice to be made. There also you should stop. So they call these two circumscribing boundaries. Well, we applied it to the SMA. We said that you should interpret it as if they are heterosexual couples. You should interpret it in the larger purposive context. You should interpret it in a object sought to be achieved, and there are no particular circumscribing boundaries because we are not asking you to make new legislation. The existing framework should be able to support it. We, of course, did other things, the wider things, like citing also cases on original intent, which is not a doctrine which has ever been a limitation in India. But we pointed out that Brown versus Board was specifically the American case. The original intent of the framers were never to apply to desegregation explicitly, but it was applied. So the fact, because the argument of the other side was, after all, the SMA never imagined or dreamt of same-sex couples. Why the hell should you be stretching to do it? So that we said cannot be limiting. Fifthly, the problem which arose was about the nitty-gritty of the SMA. There were a lot of provisions which did not just fall into place with just spouse or person or neutral words being used like, couples. One of the problems was personal law, a major problem in India, not so much in other countries, because a constitutional compliant interpretation of the SMA, which recognized same-sex marriage and the existing words of the SMA, could be faulted for violating the personal law of certain communities. So, first thing we said is that we are only limiting our arguments to the SMA. Second thing we said is we are not concerned about touching remotely any person. No. This was not only a self-preservatory submission on our side, it's not only a case of discretion being the better part of valor, but it was also correct because the SMA is a religion-neutral, agnostic legislation which was designed many decades ago, no doubt only keeping in mind heterosexual couples. But leaving that aside, it was designed for people of two different religions, ethnicities, etc., to marry on a secular platform, which is called in India loosely a registered marriage. And the whole idea was to provide the override to personal laws, but where parties voluntarily wanted to eschew personal laws. The second problem which arose was that it dealt with most conditions well, because all the cases of consequences of recognizing a same-sex marriage, like succession is a major consequence, were fortunately governed by, again, a religion-agnostic law called Indian Succession Act, the Long Act. So we pointed out that a Muslim with a Muslim, a Christian with a Christian, I'm talking of same-sex couples, a Muslim with a Christian, a Hindu with a Muslim, or a Hindu with a Christian, all of them would be covered by the ISA under the existing law, which is again an agnostic signal. The problem, however, arises Hindu with a Hindu, where the Hindu Succession Act applies. That was the second problem put to us. And we said, either you use words which say that this is obviously a choice by two Hindus to marry under the SMA, and that will be paramount. And you clarify that you're not touching the Hindu succession issue. So, there was this kind of pick and choose process because it's a new area. And the whole problem we suffered from was that we could not ask for legislation or even a drafting of a small little minor code that would frighten them off from signing it. Lastly, there were other provisions of the SMA, which are what are called heteronormative provisions. Heteronormative means broadly that they are, by concept and design, only applicable to one sex. Adultery, rape, sodomy, bestiality. There are provisions like that in Indian law. Some of them find place in the SMA. You cannot have a sex-neutral interpretation of rape. So we said that that is a wrong objection. This is a case limited to attacking discriminatory and exclusionary paradigms. This is not asking for reading up or reading down or challenging anything to do with heteronormative. So when our entire challenge is based on reading up or reading down discriminatory, exclusionary paradigm, why the hell are you taking us to heteronormative things? Because we don't want to. This case did not deal with it. So that was the answer we had to give there. This is broadly the construct in which the narrower legal arguments for lawyers like you to understand were made. And we also, was the central theme I forgot to mention was that marriage as a label of recognition by the courts is itself a very important status to be given to lesbian or gay couples or other forms of gender basic. The institution is itself not merely a word, but the institution of marriage giving you a co-equal ownership of society as married couples is a vital part of the entire human rights construct. And for that, we ended by saying that a civil union, most case countries have it by legislation, is not a sufficient substitute. It still does not allow you to partake as an active stakeholder in the valuable social institution of marriage. So don't think that an easy way out is to substitute civil union for same-sex marriage. That was what I said as far as the legal arguments are concerned, and we await with bated breath the church. As I end, I want to just go, because this is obviously not a case of law though, and happily I am in some way associated with all three organs of state. Happily or unhappily, fortunately or unfortunately, equally unfortunate. And there, this case, according to me, will be decided as much, if not more, by the factors and facets without or outside of the legal issues which I just summarized. not so much or maybe partly lesser by the issues within, more by without and less by within. The without issues or the outside issues became more and more important as the arguments progressed. The arguments were heard, of course, with great attention, respect, receptivity. But as the matter went on, it realized and I'm just summarizing very quickly before I end, that the government, of course, is opposing. It was always in its reply and pleadings opposing. But the vehemence, the degree, the bigger, the almost fanatic nature of the opposition of the government was underestimated. So the government went all out. We opposed so many cases. This was a very, very strong opposition. Third, the government went to the extent clearly of seeking and getting support from a diversity of interveners, NGOs, press placements, so that an entire ambience, a cacophony was created. A noise system was created in society for those 2 or 3 months when this went on, suggesting that this was sacrilege about to happen. This was doomsday coming. This was sky falling on the heads of India. It was that, you must believe me when I say that the crescendo reached those limits. And it's an admirable achievement for letting it. Only the government can do it. An admirable, creditable achievement to create the surrounding ambience like that. Number 4, this contextual surrounding ambience is not never so important as in a case like this, because it's not decided on legal issues alone. So you have to realize that in matters like this, which are the cutting edge of creativity or whatever, ideologies, etc., judges are cleverer than we think they are. They allow progression, development of law, stretching of law, making judgment law. Every judgment creates law, legislate. This whole thing about usurpation and necessary power is conquered. This is always treating law. But they are very clever to create law within limits, in an incremental manner. And they are even cleverer than what you think and what the rest of civil society is first testing the waters. Putting your foot in and see how hot or cold it is. And that they stretch the rubber band as much as they can. But always a millimeter behind the limits of social opprobrium, social negativity. They don't want to be unpopular at all. They want to be popular, they want to be accepted. So the whole impression created was that you'll be usually unpopular, you'll be outcasts, you'll be, considered as traitors of society if you did this. And that is going to be the biggest challenge in the judgment which we await. First is, should we at all go down the path? And second is, if we go down the path, how much? Second is obviously more important because I think something we will get. But for example, to give an example, to get a declaration of the judges that we recognize cohabitation of same-sex couples. Sounds grand. It's a damn squib. For cohabitation today, in any form, I don't need anybody's permission. Since you've decriminalized private, consensual, homosexual sex, since those days, a few years ago, as you know, we decriminalized it in India. You have no problem in private behind the doors cohabitation. So you are actually making a broad declaration which is empty and hollow. Second, if you go beyond that, you must recognize specifically marriage, which is beyond cohabitation. Thirdly, if you recognize marriage, how far do you go in adoption and succession? 2 vital examples. There are many more. Fourthly, if you go down that path, then how many of the other secular irritants of civic life, I call them irritants of civic life, are you going to get? The insurance clause, the child's name, the form filling, the employment job, the relationship between people in your travel, passport, etc. Now, these are the issues. And therefore, if question is there, but even much more is how much. Lastly, clearly, one other part is a very important part. which only a few petitioners like mine raised, which is now deferred to another day. It's been made clear it won't be decided, but it won't be rejected. It will be decided, but by a normal bench, not a constitution bench, not by this judge. Is a peculiar part of the SMA which has sections 5 onwards, which is what we call the notice and objections regime. Now, even before the same-sex issue, forget the same-sex issue, in normal issues of heterosexual union, there is a notice and objections regime, which means that if a Muslim and an Hindu or anybody heterosexual of any religion wants to marry under the registered marriage provision, they have to give a 30-day notice. And then that notice invites objection from the word. Look, this should not happen because this is bad. This is good. The idea is noble. It's a bona fide idea. But actually, in practice, a bona fide idea is resulted in the exact opposite of what is intended for. I'm talking of pre-gay sex issues. In heterosexual marriage, it has led to oppression and intimidation and intervention of a negative kind, never intended by the framers. Because those who oppose a Muslim-Hindu marriage, they can't start wielding sticks in those 30 days and scare you and kidnap you and abduct you and do crimes with you. So already you have a parallel. Imagine how much more that will happen if a family member of mine has a gay union with a 30-day objection period. So we said that must be struck down. They said, certainly a bench, in the light of the judgment we're about to give, we decide that, but that is deferred for another day. So this is the whole canvas, the legal, the non-legal, the extra-legal, the social, the emotive, the psychological, all of them in this heady cocktail, which we now await. Thank you.